We've been interviewing Mary Ryan, who is a solicitor by profession, but she's now an independent consultant with Ryan Tennard Brown. And she's been working with the FDAC, that's the Family Drug and Alcohol Court national unit, on the wider rollout of FDACs. And she's also been part of a team working on follow-up research into the impact of FDAC.
FDAC stands for the Family Drug and Alcohol Court, and it takes a very different approach to assessing families and helping the court to decide what to do for the protection of children. We're particularly interested to know whether the model that FDAC uses, this problem-solving approach, could be applied in private law disputes about childcare, and where there may be domestic abuse or other problems occurring between a couple, where problem solving may be extremely necessary rather than the current adversarial approach, which may not actually get to the bottom of the problems. So would you mind just telling us a bit about the FDAC, how it started and how it works?
Yeah, sure. So the FDAC, Family Drug and Alcohol Court, as you've said, the first one of those in England and Wales was set up in central London in 2008. It's what's called a problem-solving court. That's a model of way of dealing with court proceedings which comes from the United States and is also in use in other jurisdictions fairly similar to ours, like Australia and Canada, but mostly it's from the United States. And it's based around the notion, when you talk about problem solving, people might say, well, all courts solve problems in one way or another. But the approach of these courts is particularly, it's so far as I'm aware, I'm not aware of it being used in what are called private law proceedings. So that's proceedings, on the breakup of a relationship.
Yeah.
It tends to be used more when the state is intervening, and that's either in criminal cases or in cases of care proceedings when the state is intervening to protect children. And the idea behind them is that in these courts, you often see the same people appearing time and again who've either committed crimes or who are coming back having children removed because they've got an underlying problem. And that could be drugs and alcohol. There's also domestic abuse. There's also mental health courts that are working, that are problem-solving approaches. And the idea behind this is linked to something called therapeutic jurisprudence, which is the notion that courts in these systems, which are primarily adversarial systems, have more of a role to play. They're not just there as arbiters of this evidence and that evidence, and I believe this person and I'm going to make this decision. It's all about what underlies the issues that are being brought before us, and can the court be an active participant in helping people to make the changes that are needed in order to, in the case of the family drug and alcohol courts, help them parent their children safely so that those children can return home. So the theory behind the courts is that they should have trained judges, so judges who are specially trained to do this, working very closely with a specialist multidisciplinary team. And that team, in the case of the family drug and alcohol courts, is made up of social workers, substance misuse workers, and it often has other people who might, for example, be specialists in mental health, adult or child, or in something issue like domestic abuse. There are also people who come in to support and train parent mentors, because another element of these courts is that when people have been through them and have succeeded in dealing with their problems and being able to have their children home, then they go on to provide support, peer mentoring support to other parents going through the system. So the way the courts work in England and Wales, the normal process for care proceedings is followed. The local authority starts proceedings in the normal way. And if the case is referred to an FDAC judge, they will have the same judge throughout. So there's none of this changing of judges that you often get in court proceedings. And they have the support of this specialist team. So the team have varying roles. They provide direct work with the parents. They engage the parents. They help them, they assess them, they plug them into local services as well as providing services themselves if they're not already doing that. They also advise the judge, so they are providing the judge with regular information. And the judge sees the parents on their own, away from the lawyers, alongside a member of the specialist team. Social workers will come to those what are called non-lawyer reviews. So the idea of those meetings is that they're held within a court. The judge is the chairing the process, if you like, but it's not a legal, normal presentation of evidence. And at those meetings, the judge is talking to the parents about how they're progressing with what they're doing. They hear from the social workers about how the child is doing, and from the team about any issues that are arising. If a point arises where there's some kind of conflict that will require a legal decision making, then the judge says the next of these appointments will happen with the lawyers here. And those reviews happen every fortnight. And the point about evidence there is that although FDAC wasn't set up to improve the evidence, in a way problem-solving courts do, because what they're doing is providing the judge with the ability, and all the other parties actually, because those reviews, notes are taken of those reviews and circulated to everybody. Everybody's kept up to date with what's going on. It's what's called a process of dynamic assessment, really. So sometimes in care proceedings, you would have the parent sent to a psychologist or a psychiatrist who would do an expert assessment, prepare a report, and that report would then be presented to the court. Well, that's seeing the parent at one point in time, looking at the parent's history, making a prognosis for the future, making recommendations. What happens in FDAC is that all of that is happening in front of the court. So the assessment happens, the issues are identified, and then the work begins with the parents. So all of that is happening alongside the normal discussions about possible placements for the children in the future, contact and such like. So that's the basic principles of how they work.
Can I just ask one or two things about that? Who decides to refer the family to the FDAC? Where does that decision come from?
At the moment, it comes from the local authority, because the local authorities are the ones who are funding the specialist teams. So they provide the money, or they reorganise their services, but usually it is extra money that they have to provide to bring this group of multidisciplinary group together, who are co-located, they're working together. It's not something they're doing as part of other pieces of work. They are specialists focusing on these court proceedings with these parents going through.
And so those teams are usually already established teams who specialise in treating drug and alcohol problems, are they?
Not necessarily.
Right.
Not necessarily. In fact, mostly not. So they vary. The commissioning processes vary for them. So the first one, the people who provided the specialist team was a combination of the Tavistock and Portman NHS Trust, who brought sort of mental health experience and also expertise in assessment, and the Coram family. I can't remember what Coram calls itself, the charity who provide some of the social workers for that. So that has continued to be the case. So they have, within that, they have brought in substance misuse experts, as well as the clinical psychologists and the social workers. In other areas, it varies. So in some areas, there's been an existing assessment team for the local authority, and they've expanded that team to include the people they've needed. Some have just set up a completely sort of new seconded team, which brought in people from treatment services, from social work. So it varies. And one of the issues for FDAC is persuading the local authorities to fund those specialist teams.
Of course.
Obviously, local authorities are hard pressed for cash at the moment. So we have a constant, those of us who work on the sort of rollout of FDAC with the Centre for Justice Innovation currently, looking at ways in which FDAC can be made more sustainable, which really is about the funding of the specialist team. some, whether that couldn't receive more government funding than it does. It's not just a children's service. It involves adult services. How can we get people involved? In some areas, the police and crime commissioners contribute to the service because of the domestic abuse element of most of these cases. We also get some money, some interest from Public Health and from NHS England in terms of putting some money in. But it is a constant effort, actually, to find the funding for them. But what it is saving people is the money they would otherwise be spending on an expert in those proceedings.
What's the impact, Mary, on the parents? Because doing care proceedings as they normally are done, non-FDAC care proceedings, you end up often with a big fight. I mean, that's the easy colloquial way of putting it, in court, with a judge having to decide. It sounds to me, and correct me if I'm wrong, but it sounds to me as though you're bringing the parents along with you because you are they can see why people are saying things because you're there with them all the time, practically explaining that this is a problem. Do they accept the outcomes more readily because of that, do you think?
They do, and I don't think it. I mean, we've established that through the initial pilot, which lasted for 4 years. There was an independent evaluation of that carried out by Judith Harwin and a team, of which I was one, funded by the Nuffield Foundation.
Yeah.
And that found very clearly that they operate in a very distinctive way, these courts. Firstly, it was more successful in getting parents to stop taking drugs and being able to be reunified with their children, and significantly more successful in terms of the numbers. But the other thing we found was that even where parents couldn't succeed, and actually even within FDAC, the majority of parents don't, it's a minority, it's just a bigger minority than in ordinary proceedings, they are better able to understand why people are concerned. Yeah. And there are less contested final hearings in FDAC. And when we did a follow-up study where we followed up on families who'd been through FDAC, as well as the families who'd been part of the comparison sample, so going through care proceedings for the same reason, but not in FDAC, we found that FDAC parents sustained their changes more successfully than other parents who were reunited. Reunifications were more solid. And there was pretty strong evidence that there were fewer returns to court. So there were less cases of parents having children again and having to go back into proceedings. So there's really, what I feel very strongly about it is that it's a much more humane process.
I was about to say that, yes.
And parents say when interviewed that they have, it's very different for them. They feel people are listening to them, are genuinely trying to help them, that people are honest with them. It's made very clear to people it's not going to be this isn't an easy option.
No.
People are honest with them and they encourage parents to be honest with them. So if parents have a lapse, which is very common with people trying to come off drugs and alcohol, they're encouraged to talk about it, and their ability to own up and be honest is, then praised by the judge for something well done for doing that. It's unfortunate. Let's see if we can't get back on track. And they talk a lot about how their relationship with the judge is very important to them as well. They get to know the judge. They feel, because we live in quite a hierarchical society, I think, for them having this person of importance who is, listening to what they're saying, asking them questions, wanting to know how they're feeling, how they're doing, is really, really important to people. So it has all of those. It has all of the things that people are saying should happen within social work now, which is relationship-based. It's also trauma-informed because there's a real recognition that people are where they are because of their own
things that have happened,
poor experiences in the past, yes. So.
And the other aspect of that is that even if people do badly or fail or relapse too far during that process, in my experience of treating alcohol and drug problems, people sometimes have to come back repeatedly in order to learn. So although you have a fortnightly process within the FDAC, but if people fail to convince the court that they can care for their children well enough, they may have more children later, and reappear. In which case, any learning they've done in the first experience of FDAC can then be built on. In other words, you can make further progress later with subsequent children in a way which you can't if all you've had is an adversarial battle, people defiantly saying, I'll have more children and keep them this time. You may actually have a learning process which goes on over a period of time which is longer than simply the one episode in FDAC. So I don't know if you may be getting people coming back after having one child or children.
There are some cases which come back. I mean, again, it's down to the local authority to decide whether they want to refer that family in.
Of course.
Certainly all teams, I think, have had experience of having a family back. All teams occasionally have the bad experience of, it all seeming to go very well with children returning home and then it actually collapsing afterwards. But again, there, when we did the follow-up, what we found was that parents were very quick to ask for help. So, one of the things it does is shift the attitude of parents from being very resistant to any form of support and help to recognizing actually that they need to ask for that and they need to get people to help them access the help they need. So, it does shift things quite considerably.
And one of the things that makes it different is that you can have feedback to the court about a result of testing for drugs or testing for alcohol. But that can't be the only criterion about success. There may be many other aspects of how parents are functioning which feed into those reviews. It's not just about sobriety or abstinence. It's also about other aspects of parenting or parenting capacity.
Absolutely. And an awful lot of cases involve domestic abuse, either current or past, or they involve mental health issues. Sometimes, low-level mental health, so not at the sort of level of that has got people into adult services, or they have people who've been misdiagnosed. There are quite a lot of parents who come with a diagnosis of emotionally unstable personality disorder, for example, things like that, which it's now increasingly being recognised that may often be complex trauma, there is now a proper diagnosis of complex trauma. So it's kind of how you're responding to those issues and the recognition, being able to work with some of the elements of that, because mostly people have had poor parenting experiences themselves. So a lot of why you have social workers in the team and also clinical psychologists at times is to do that work around parenting and child development. The teams the way in which they work is they stabilize people. They check that the drug and alcohol issue is and then they begin to work on parenting. They use a lot of video action guidance where you're working with parents and children and looking at the interactions between them and helping them develop their abilities to reflexive parenting and mentalization and all those kinds of things.
Well, anything that gets people away from using a diagnosis of personality disorder is a good idea. I mean, by definition, ICD, whatever, personality disorder is only counted from adulthood onwards, and quite obviously personalities are formed in childhood. So the disorder is likely to have been caused by traumatic experiences, because babies aren't born with personality disorders. They acquire them through experience. But substance misuse itself is a very poor prognostic factor in most problem situations, because it means that people become unreachable because they're intoxicated or they're ill due to the substance misuse, which means that you can't really work with them while they're using drugs or alcohol heavily. And so in some families where there isn't a substance misuse problem, but there may be all the other difficulties that you come across, the domestic abuse and the traumatic experiences that have shaped the personalities, you might think that an FDAC approach might be more powerful, might be more effective, in fact, because you remove the substance, you haven't even got the substance misuse problem contaminating working with them. And you might think that the FDAC model would be even more effective outside of drugs and alcohol misuse.
Well, we've certainly argued that it could be used outside of drugs and alcohol, and there are a number of teams that have certainly done, one or two, but not many cases which haven't involved drugs and alcohol, and done them successfully. Both examples have been of where there's been physical abuse of children, where there's been domestic abuse is another one. I think one of the issues is because drugs and alcohol is easy to measure. You're absolutely right. You put your finger on it. It's easier to say at the end, okay, this is successful. You are also looking at parenting. So there are cases where parents come off drugs and alcohol if they were on alcohol as well. But actually they can't parent for whatever reason. It's not going to be safe for them to parent the child. And that's the teams are very good, I think, at helping parents to understand what the issue is there and why that is. Not always. Some people, just walk away at that point. But I think that's where that whole process of really trying to understand what's lying behind the substance misuse and dealing with that and getting to that as quickly as possible. It's also having to be done in this very tight timescale now of 26 weeks in care proceedings, which is a big ask in these sorts of cases. And the judges will extend proceedings if it is looking as if the parent is making good progress, and it would be in the interest of justice to allow the case to carry on for longer than the 26 weeks.
How often does that happen, do you think, that it overruns the 26 weeks? That judges decide to overrun the 26 weeks?
It usually happens. It will happen if the case is looking positive. So if the percentage of cases within a team where they're looking like a success. I mean, the other thing that happens if it's not looking like a success, then courts are much more able to reach a well-informed decision at the end of the hearing, at the end of that period. Whereas you worry sometimes in other cases that, people are rushing to a 26-week decision without really having all the information. Whereas within FDAC, you do at least feel they've had the opportunity to really look at, and if it's not working, then you feel confident in supporting the parent to understand why that is.
Yes, there's a real problem with that. I mean, there's plenty of evidence that permanent change in behaviour probably takes at least 6 months, maybe a year, to be reinforced, to be stabilised. And anything which tries to cram it into a short period is really setting people up to fail. But of course, children have their own timescales, so you have to find that compromise between what the child needs and what's possible for parents. That parents may not be able to change within a timescale for the child, even if with the best will in the world, that change simply cannot be crammed into that period of time. So it's very humane if you can extend the period, but if children clearly have to suffer that delay, don't they?
Yes, which is why it's the teams in doing their assessments and feeding to the judge and the others. They're very clear about the timescales. They say, they're clear about the timescales of the parents, but they do say, it does depend on the age of the child and the situation. So, it will need to be, things will need to, there'll need to be evidence of change quicker for a baby, particularly if there isn't a family placement available. But for older children who are living with relatives, for example, there is the possibility of arguing that this, it can be extended as long as children know what's happening and understand what's happening.
How much do you think it costs, Mary? How much do you think a case costs now?
Actually, that's good question, frankly, because really nobody knows how much care proceedings cost. If you asked a local authority, how much, to try and get a figure for an average set of care proceedings, it's the numbers that you see are varied. The Family Justice Review in 2011 came up with some figures. There's been figures produced in other reports as well. Nobody has really put their finger on how much it costs. An FDAC per case, if you want to break it down like that, they would say it's about £14,000 per case.
Well, we're talking to people in private law who are spending £30,000 or maybe even £50,000 on their legal costs, their own legal costs, And that's not achieving very much for them. And that's kind of what we're hearing. So there's a lot of money washing about in the private law to pay for something which is not clearly helping families. So it's an interesting comparison to make.
That doesn't sound expensive.
That's the cost of the team. That's what the team,
of
the
course.
specialist team. You have to then factor in. There are lawyers involved who are coming to some of the hearings, and obviously the judge's time. But I mean, if you were thinking about, I was looking to see whether I've seen any examples of problem solving in private law, which I'm not aware of. I haven't found any. But I know that there is activity currently around in private law looking at trying to do things a bit differently, testing out different ways of doing things in order to deal with the backlogs that there are and the long delays that are taking place, and really the dissatisfaction, I think, overall in the way in which a lot of private law issues are managed. And so a number of the lessons from FDAC, I think, are around, if something seems like a good idea, there's an idea for doing things a bit differently. What we've learned from FDAC is that it's really important to pilot it properly. Have a properly funded pilot that's set up well and that is independently evaluated and is allowed to run for long enough so that you can really get a sense of how it's going to work or not. So you need we argue with FDAC, you need really at least 3 years to test out whether it's working properly. I mean, most funding has allowed for about 18 months or up to 2 years to test it out. You need proper training. You need a team to be trained properly to understand what they're supposed to be doing, and you need the judges to be trained. And what we've learned from the training of judges is firstly that they like being trained and, comment positively on their opportunity to have training. They also like the opportunities to meet. They meet once a year, all the FDAC judges, to talk about issues. They exchange. They're in contact with each other. They support each other when they're setting up new ones and things like that. And the judges themselves are able to operate in this way that people were very sceptical about to begin with. The judge who set it up in London was called Nick Crichton, and he was sort of well known for operating in a slightly different way to other judges. And people said, oh, well, it's just Nick, only Nick can do this. But actually, it was never just Nick. There were other judges in the London court. And now there are judges in the 14 FDAC courts dotted around England and shortly Wales, who are very good at having these conversations with parents, at, being able to both be, motivate parents, but also be very clear when things aren't going well and warning them that they need to, change this or do that if they're going to get the result they want, bringing everyone's attention back to the focus being on the children. That's what everyone's concerned about. And so and they themselves, I've heard judges say on a number of occasions that, it's the best bit of their job. It's very hard because very often they're not able to reunify children back home. But they say it's very rewarding because they are very, aware of the people in front of them. They're very clear about what the evidence is, and they feel much more in control of the situation than they do with some other cases.
What's the role of the children's guardian in the FDAC proceedings? Is it limited or is it exactly the same, Mary?
It's theoretically exactly the same, and in some courts, some FDAC courts, but not many now, there are dedicated guardians. So of the local guardians who serve that court, there are some very few FDACs where there are dedicated guardians. So 1 or 2 of the local team will always deal FDAC cases. In other situations, it has become more difficult now because of the very limited role of guardians in care proceedings. And it can be very problematic. What we would like, what the sort of FDAC training suggests, is that it's helpful if the guardian can come to the first multi-professional meeting, which is called the intervention planning meeting, where the parents come, the team is there, social workers are there, any treatment services, and if the guardian can be there as well, to hear what the plan is, what the FDAC plan is, and how they're going to work it, because that becomes the care plan. And then we would suggest that it's helpful for the guardian to come to 1 or 2 non-lawyer reviews so that they can see what's happening there, and get a sense and understand it, and that they read all the notes that have, come from that, the information, because the worst situation is where the guardian is appointed, doesn't come to any of the meetings, doesn't come to any of the non-lawyer reviews, and then sort of pitches in towards the end of the proceedings when everyone is agreeing a way forward and says, no, I disagree. And yet they haven't been part of that. So then there's a whole issue around dealing with that and trying to explain to them why we've got to that position. So there have been some concerns expressed, and judges expressing concern that really the guardians can't sort of sit back and say, oh, this is going through FDAC. They need to be involved. They need to understand what's happening. They need to understand the different way in which the evidence is being presented. Otherwise,
but the judge can end up knowing more than the guardian, really.
Yes.
And having to explain it to the guardian rather than the other way around.
Yeah.
Which is kind of ironic. Yeah.
Yeah.
And also ridiculous.
Well, ridiculous, yes. But Mary, I think we should wind up there, and thank you very much for explaining the FDAC to us.
Really interesting,
and
Mary.
It's very helpful, I think, for people who are finding themselves in the family court, clearly facing a difficulty in getting people to understand the problems that are happening and finding solutions to them. So thank you very much for helping us understand what's happening.
Thank you.
Okay, not at all. Delighted to talk about it. All right.
Thank you.